on family mediation and dispute resolution. It's my pleasure to privilege the address to you all on behalf of ICFI Law School, Dehradun. I would like to welcome our guest speaker, Mr. Deepak Advocate Deepak Agrawal. I would also like to welcome our Mrs. Monica Khorola, our Assistant Dean. Now, I would request Mrs. Monica Khorola, ma'am, to take the session further. Over to you, ma'am.
Thank you, Monica. And it's firstly a pleasure to welcome Advocate Deepak Agrawal to this session, and he's agreed to talk to our students relating to family law and ADR. So I would like to, in brief, just tell you that why it is important and how it is important, this session. And it is part of a long journey that we are taking up these issues so that the students can know more about the topics. As you know that today, ICFI Law School is trying to explore all areas to make the students familiar and to enhance their application of the law. So in this regard, this ADR cell has invited Advocate Deepak Agrawal for discussing ADR and family law, how they are to be utilized for the benefit of the people. For example, we have seen that family related matters take up a long time in the courts like all other matters do. And it is important that people don't have to suffer such long delays. Sorry. They should not, suffer the long delays in the court. And the lives of the people who, due to family matters, get into legal tangles, they suffer a lot. So the courts and even the family law itself has focused on resolving the issues firstly by amicable process and then through other mediation processes and other processes that can be utilized in resolving the cases. So beginning with conciliation and then to other forms of ADR, if they can be utilized for dealing with family law cases, it will be a great relief to the people. And advocates are playing a great role in trying to see that they are able to mitigate the problems of the people. And that is why today, maybe in the family law matters, things are being expedited, and this is helping in order to resolve and to make life better for those people who have to take litigation regarding to family law. So the focus on today's lecture will be how to utilize ADR for resolving family related matters. And I'm sure that Advocate Deepak Agrawal will give to our students the details of how a lawyer faces these cases and tries to resolve them to the best of the interest of the client. And that is the objective, that the law can be taken to the doorstep, and the bar council or even the courts, they have focused on utilizing ADR in order to make things more fast and to help citizens get better justice. So this ease of justice can be achieved through ADR, and our students who are studying family law, they will be able to appreciate how they can utilize ADR to resolve disputes relating to family cases. So with this, I welcome Advocate Deepak Agrawal and thank him for. Over to you, Monica.
Thank you, ma'am. Thank you for the welcome note for our guest speaker. Now, I would like to introduce our speaker of the day. I'm sharing my screen. I hope this is visible. Ma'am, is this visible?
Yeah, it's visible.
Advocate Deepak Agrawal. Advocate Deepak Agrawal is a law graduate from Bangalore Institute of Legal Studies, Bangalore University, BLLB 5-year course, Karnataka, and is a member of Bar Council of Delhi since 2009. Since 2009, he has been handling writ appeal, civil, labor, service, banking matters pertaining to NI Act, and doing arbitration cases for and on behalf of companies and execution petitions in the various high courts and district courts of Delhi and various industrial tribunals, labor courts, and consumer dispute redressal forums on behalf of individuals, firms, and companies. Mr. Deepak Agrawal has successfully represented individual and government employees before CAT Principals Bench, Delhi. Mr. Deepak Agrawal is presently impaneled as an advocate for Karnataka State Open University, Delhi Jal Board, Delhi Jal Board, Messrs. Arun Vastra Bhandar Private Limited, and has been formerly in the panel of Messrs. HDFC Ergo Company Private Limited. Panel lawyers for DLSA, Southeast Saket Court, Delhi Messrs. Suchitra Constructions, Messrs. Gotham Builders, Messrs. Sulekha Enterprises, Messrs. Ruchira Groups Private Limited. So we welcome you, sir. And by this, we start the session, and over to you, sir. Please grace our session with your words.
Thank you, Dean man. Thank you, Monica ma'am. Thank you for welcoming me to this session. Thank you for your kind words. So let us start with the session. Can we just, instead of having a normal speech session, can we have a little interaction session? So just students can tell me that which year they are, if they can unmute their mic and camera, at least their mic, and say which year of the law's 5 years LLB course they are, 4th year, 5th year, 3rd year. If students can tell that.
So actually, if they'll raise hand only, then we can unmute them.
Okay, can you raise hands, students, so they can raise their hands, so that they can be, at least we can get a fair idea. That basically the idea is to know that which of students have read anything about family law. Yeah, I think Shuyash Singh is there. Monica ma'am can ask him, can unmute him.
Sir, let me just contact the technical team. I guess I am not unable to unmute them. So just give me a minute.
Permission hai, ma'am.
I think you can, ma'am.
Okay, ask to unmute. Yes, Suyash, now you can unmute yourself. I don't think so. Sir, let's just remove the restriction. I'll just contact technical team.
No issues, no issues. We'll continue with
Good
this.
afternoon, ma'am.
Yes, yes, Suyash.
Good afternoon, sir.
Good afternoon.
Sir, I'm in 2nd year.
Okay, so have you gone through any law subject as of now?
Yes, sir.
Which all subjects?
Sir, Hindu law is going on, IPC and Constitution in this semester, in this year, sir.
I think Hindu law should be helpful to you in this. I think this will help you, this ADR with regard to Hindu law. Anybody else? Anybody else have gone through any Hindu law, personal law, family laws, domestic violence law, constitutional law? I think Ayush is also there, Monica ma'am, if you can unmute him.
Yes, so we have. So we contacted to our technical team. They'll remove the restriction.
Okay, no problem, no problem.
Permission दे दी गई है अपना, कोई भी unmute कर सकता है.
Okay, thank you, sir.
Okay, now taking it a little forward from here, I think let us go a little forward. What this ADR alternative dispute resolution means. So the topic for today is family mediation and dispute resolution. So have you seen that the topic today is family mediation and dispute resolution? So we all know what the dispute resolution is, alternative dispute resolution. That is something we're trying to resolve, which is not within the four frameworks of the court. I mean, not court per se, like in legally, it is something out of the court, which is legally enforceable, though it has been done out of the court, but still it becomes legally enforceable. Now this aspect touches a little bit of family. Now, once the family words come in, now something which has become little emotional between the people, which is no more, something which is commercial in nature. So this has to be taken care of little more in an emotional manner, in a sympathetic manner, rather than making it a commercial venture. So for that reason, we have this sessions calling family dispute resolution session, family mediation and dispute resolution. So in a family, as we all know, it's little emotional in nature. So what is the origin that we look for? And as a lawyer, as a legal profession, you people would be joining the legal profession soon, maybe 2 years, 3 years down the line. So what would your role be in a society to pay back to the society? So once the alternative dispute resolution we start, the first thing which comes to our mind is, I think more or less, most of the people would be thinking is arbitration. That is the most alternative dispute resolution is. Am I right in this sense? If people agree, they can raise their hands, even if it is there. Do you people agree? Have you ever heard of this? I think someone has replied on the chat. He's in second year. Okay, note taken of that. Okay, so have you heard of Arbitration and Conciliation Act? But here, I don't think we'll be dealing with Arbitration Conciliation of Act, because the Arbitration and Conciliation Act is more in a commercial nature. Here, what we would be dealing is, we'd be dealing of little bit of family laws. So what are those family laws which help us to, to structure a family dispute? So before we go there, just let's understand what kind of family dispute are, and what is a family dispute, and how does it land up in a court of law. Family, as you can understand, consists of male, female, mother, father, husband, wife, their children, brother, sister. This all constitute families. The family, for our understanding, will keep in two parts. Family dispute would be a property family dispute. Another is a matrimonial family dispute. Property family dispute, as most of you can understand from the word itself, is that the concept of having an ancestral property, or the property or land or family name or family land or family shop or whatever it is, which leads to a dispute. When a father dies, he have 4 or 5 children. 4 or 5 children get into a dispute amongst each other, and that again ultimately lands up in the court. The another aspect is a matrimonial dispute, where a husband and wife are married, they have kids, and due to some issue, they're not able to stay together. So when the people get married after the age of 21, so having kids, so whenever this dispute, such kind of dispute arises within the family, it is generally the husband and wife who are within young age of their life. So is it okay as a human being to continue them like this in the suffering which goes on in the court day after day, or should we move ahead and see that, okay, what is the way out of it, and how can a law help to them? So for that, we'll go through the relevant provisions of law. However, there are many provisions of law, but for us, we can shortly crystallize between 4 to 5 important sections of provisions of law, which would be relevant for our today's discussion. So first of all is that we can say Arbitration and Conciliation Act, but Arbitration and Conciliation Act is more in commercial in nature. Though it provides for arbitration, it also provides for conciliation. But since it is related to more to an arbitration which is commercial in nature, so for a time being, we can say that, okay, it might not be that relevant for our today's discussion. We can come to second provision, that is Order 23A, that is Order 23 also we call it, that is in CPC, which shows that, which provides that in case of settlement, how the settlement is to be done, and what is the nature of settlement, what is to be done and what not. Number one. Number two, Section 89 of CPC. Section 89 of CPC provides that in case of dispute of any nature, can be referred to arbitration, conciliation, and mediation for settlement. So 89 is also one of the provisions which empowers the court to go ahead and get the matter referred to a mediation and get it settled. Then comes the Lok Adalat Act. There is an act called Legal Services Authority Act 1987. It has been enacted, and this act is applicable throughout India, where it provides for a permanent Lok Adalat. As we all know, Lok Adalat is something which happens there, but generally we have a mindset that, okay, it's a Lok Adalat, so it is only for, just to settle some traffic issues, traffic challan or some petty disputed. But that's not the case. In practicality, Lok Adalat are also there where the permanent Lok Adalat, which can be referred, and mediation family dispute can be sorted out there as well. Then comes section 23 of the Hindu Marriage Act. Some of, I think, second year student, those who are in second year, they must have gone through this, or they would be required to go to section 23, which mandates, which, or you can say, which directs the court or provides that before proceeding with the matter, whenever a family dispute comes to a court, then this matter is compulsorily, court refers it to mediation or asks the party to settle the dispute rather than continuing in a litigation, long end litigation. Then comes the recently enacted is the Family Court Act 1984. Now, what is this Family Court Act? This Family Court Act is a new act which has been enacted and of late from last 10 years, if you can say so. So this act has gained a lot of prominence. Reason being, the family dispute rise in the society due to the various social problem, the societal problem which we are going through. People are having a lot of issues. So most of this dispute land up in the family court. So once it land up there, so a separate section of courts has been created. That's called family court. So this court looks into the dispute which basically deals with the family matters like matrimonial, custody, divorce, maintenance, alimony, child maintenance, child welfare, temporary custody, permanent custody, and it also includes Domestic Violence Act as well, which provides that a woman can also seek remedy whenever she is domestically violated, either physically, mentally, financially. She can go to the court and seek her remedy. So that is something there. But with regard to the definition of family given, in a definition, the definition includes a husband and a wife. So domestic violence per se not may fit into the category of family, but yeah, that is also a form of alternative dispute resolution. It can be. So that is also one of the aspects. So let us just start with Article 21 of the Constitution first, which says what? Article 21 of the Constitution declared that no person shall be deprived of his life and personal liberty except according to the procedure established by law. So why are we referring to this article? Article 21 we are referring to is for the reason that the whoever individual in this India living in within the territory of India, he has a right to live in a human dignity. So to have a human dignity, he also need to have a peace of mind and a good setup for which he can grow and prosper in his life. So it is very, very important that the state provides him proper mechanism for dispute resolution so that in case of his any dispute, he can go there. Then just for the reference of it. So let us start with the section 89 of the CPC, which says dispute resolution outside the court. What does the section 89 says? Section 89 says settlement of dispute outside the court. Where it appears to the court that there exists element of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observation. And after receiving the observation of the parties, court may formulate the terms of a possible settlement and refer the same to number 1, arbitration, number 2, conciliation, number 3, judicial settlement, including through Lok Adalat, number 4 is a mediation. So what happens then when the matter is referred, that's also provided. Let us see what happens then. When a dispute has been referred for arbitration and conciliation, the Arbitration and Conciliation Act shall apply as if the proceedings for arbitration and conciliation were referred to settlement under the provisions of the Act. Number 2, Lok Adalat. When the matter is referred to the Lok Adalat, the settlement takes place as per the Lok Adalat Act. Judicial settlement. Judicial settlement takes place as per Legal Service Authority Act 1987. Then mediation. The mediation part, which is a very important part, is that nowadays every court has their own mediation center. We may be in your district also where the courts are, and even in Delhi, wherever in India, it has become a mandatory to have a mediation center. Unless and until there is a mediation center, the mediation center helps the party wherever the smallest of dispute, you can refer it to mediation and that matter can be sorted out. And the best part of the mediation is that whatever parties want, they can speak out their mind and discuss among themselves and solve the dispute. The dispute, once solved, is written down in a piece of paper, and that paper is given an assent by the court, and it becomes a final order of the court. So both the parties are win-win situation, where a professional mediator sits there and he helps a party to get that dispute resolved inter se between them. So that is a very important aspect where the mediation takes place in the court. Then we have a Family Courts Act. So let us now see the Family Court Act. What does the Family Court Act says in this regard? The Family Court Act, which is there, which provides that any matter concerning the family, so any matter which concerns to a family shall be referred to a family court. Provision of this act shall apply to a suit, that is a case, relating to the matter concerning a family. In particular, without going into nullity of so-and-so, the disputes which can be referred to a family court is a suit or a proceedings of matrimonial relief, including a proceedings declaring the validity of a marriage, can go to the family court. Proceeding relating to the legitimacy of any person can be referred to a family court. Any proceeding relating to the custody of a minor child, not major, a minor child, whether male or female, has to be referred to a mediation. So any proceedings relating to the maintenance, either for a woman or his child, minor child, can be referred to mediation. Any proceedings relating to the adoptions of any child, any dispute has arisen with regard to adopted child, that shall also be instituted there. Any dispute with regard to family will, testamentary or succession shall also be referred to the family court. Then all other proceedings where the issues with regarding to the personal laws. I think we all know what the personal laws are. So personal laws are the Hindu law or the Sharia law, or which is the basic two governing laws, though there are other laws, Christianity law, Parsi law, Anand Marriage Act, but these two are the major laws which govern majority of the population in India. So let us for time being stick to these two acts so that it becomes easy for us to understand. So once these acts are there, so any dispute arising out of this shall be referred to mediation mandatorily. So, and the proceedings whichever takes place before a family court shall be only in presence of the parties and their lawyer. Outside parties are not allowed to attend the proceedings there, because to maintain the confidentiality and to peace and harmony in the family, it is important that such kind of inter-se family dispute is not brought into public, because that might lead to little uncomfortableness between the parties. So such kind of things are generally not given into public notice. I'll just request if anybody has any query, they can put in the chat box so that we can answer that query while taking it forward. Then what is the duty? Once the dispute is when a dispute arises between a family man, whether a husband, wife, father, mother, or a father, son, regarding the maintenance, whatever dispute it may be, once it lands up in the court. So court, what is the duty of the court? The first duty of the court would be to refer that matter compulsorily to a mediator. Every family court, not only family court, all other courts, but for a family court, it is mandatory to have a full-time mediator or a counselor who would guide the parties that to settle the matter and not to go further into litigation. Because the more and more the matter comes into litigation, we know the courts in India are limited, their times are limited. And especially in COVID times, we have seen from last 3 years, the courts are more or less shut down due to lockdown or due to curfew, night curfew and lockdowns. So it becomes difficult even for the court to perform. Half of the court staffs are positive, advocates are positive, judges are positive. We all are human beings. So once you're positive, so it becomes difficult to proceed. So somebody who has come in their flag end of their life to join, to take some relief from the court is suffering more and more due to this delay and latches which is going on. So for that, it happens that we try to solve out the dispute by referring it to a professional counselor or a mediator. This professional counselor and mediator tries to find out a middle way so that both the party feels that it's a win-win situation, and win-win situation, no one is at a losing end. the child born out of that marriage does not suffer, and does not suffer so that the child can get a love and affection of both the parents, and the child grows up in a positive atmosphere rather than growing up in a negative atmosphere. This settlement, which, how does it settlement work? The settlement which arrives between the party is written down in a piece of paper. That paper is given an affirmation by the court, as I already said. So that becomes a final order of the court, and both the party abide by their undertaking which they give to the court. What happens in the family court to arrive at that settlement? In a family court, as I already pointed out, so there's a counselor, there's a mediator. This counselor and mediator is specially trained. You might see that if in case if you get a moot court, the court proceedings, even you guys would be interning with somebody, you would be seeing that when you attend the courts. So you would be seeing that in the family court, there's a special room or place given for a mediator. He is an expert in this section who has been trained professionally by the competent authority, and he is an expert in the family matters, in the sense finding out a legal solution, not an expert in the sense that guide you what not to be done within the family. Is that in the sense that legally he can guide you, that how to go about it. So he guides the parties, he helps you to find a way out in the dispute, that how to solve a dispute and what not. So first of all, he would be asking the husband and wife what are their points in which they don't agree, or father or son, or brother, that what are the disputes between them, and try to find a way out so that it can be sorted out between them. So first of all, before we go there, let us also just understand in a brief, what does the word family means, so that to understand the legal definition of the word family, you can know that, okay, this kind of or you can say it in the sense, which kind of dispute would be referred to a family court, so that the dispute can be falls in between the ambit of a family court. The Family Court Act defines the word family, which would mean as follows: a man and his wife. People would note that it is not a man and a woman and a man and his wife, because the difference between man and his wife is that, and a man and a woman would be there. Man and a woman might fall in the category of Domestic Violence Act. That definition would survive there. But with regard to the family, it has to be man and his wife. So the difference between the Domestic Violence and the Family Court Act is the ambit of marriage. So once the social ceremony or the social performance of marriage takes place, it becomes within the ambit of family. The moment the social ceremony of family is not there, then it falls in the category of domestic violence. So that would be the Domestic Act. We may say Protection of Women from Domestic Violence Act. So that's the only two basic difference. The difference would be basically a marriage. Number one, a man and his wife living together, would any dispute arising out of that marriage would make it a family dispute. Any child or children being their issue or of such man and wife, so any children born out of that wedlock shall also be a family dispute. Any children being maintained by such a man and wife shall also be a part of a family dispute. A man not having a wife or not living with his wife, any children born out of that marriage will also lead to a family dispute. So there are two options provided, where man and his wife staying together with the children having a dispute is a family dispute. A man and his wife not staying together with children or without children, dispute arising out of it is also a family dispute. Then a woman living with her husband, not living with her husband, any dispute arising out of it is also a family dispute. The same thing also goes on vice versa. A woman with his brother, any dispute with his big brother with regard to his ancestral property, that is, woman having any dispute with regard to his family property which he has got from his father, and any dispute for the above category put together, that is singly and put together, would tantamounts to a family dispute. So these family dispute has to be dealt as per their respective personal laws, that is either Hindu Succession Act, Hindu Marriage Act, or as per the Sharia law, whichever it is. So it has to be dealt in that way. So, and it has to be compulsorily referred to a family court under the Family Court Act. Now, besides the Family Court Act, how does the system works here is that you should also take it further. Besides Family Court Act, I think if most of you would have studied this part of it, that is Hindu law. I don't know whether you studied this or not. That is something called Hindu Marriage Act 1955. I believe you, most of you people have read it. So I'll just refer to which might come in your subject of student, exams might as well. That is section 23, subsection 2. So what is the duty which has been cast upon the court in case of family dispute? Before, I'll just read out the relevant part. Before proceeding to grant any relief under this act, it shall be duty of the court in the first instance, in every case, where it is possible to do so consistently with the nature and circumstances of the case, to make endeavor to bring about a reconciliation between the parties. So this is one of the duties which has been casted upon the court to consider and try to reconcile the parties as much as possible. Number 3 is further, for the purposes in aiding the court in bringing about the reconciliation, if the parties so desire, or if the court thinks it just and proper to do so, adjourn the proceedings for a reasonable period, not exceeding 15 days, and refer the matter to any person named in the parties in this behalf, or any person nominated by the court if the parties fail to name any person, with directions to the report to the court as to whether conciliation can be and has been effected, and the court shall in disposing of the proceedings have due regard to the report. It is only to say that the court, the law, the legislature, the parliament has also made it mandatory for the courts to push the parties to push as much as possible towards reconciliation, so that the parties don't spend up their time in court and try to get out of it and just move ahead in their life, so that there is not much animosity between the parties, and they can move ahead in their life. Because after all, again, it comes back to the square one, it's a family. So family, the duty of the family is not to spend time in the court and to see each other in the court every day. So it's better you stay out of the court and try to resolve it in a peaceful manner. So that's the whole idea to do it. Then let us come to section. I'll refer to another section of it. Another section of it is that section 9 of the Family Court Act, which says that the duty of the court, again, it says the same thing. The duty of the court is to see in the first instance where it is possible to do so in the nature and the circumstance of the case, to assess the parties in arriving a settlement in respect of subject matter of the dispute. For this purpose, family court may make rules, and the family court may, as far as possible, may adjourn the hearing and ask party to think in an attempt to make a settlement. So this is the power over and above to the power given to the family court with regard to settlement, with regard to any other power given anywhere. So meaning thereby is that the family court has been given power over and above for any other law which directs or empowers or casts a duty on the family court to refer the matter to the mediation, so that the parties again try to settle the matter and try to find a way out to that dispute, and in a peaceful manner, so that they can have a peaceful life amongst each other. So that's the whole idea. Now coming to the analysis, how does the Supreme Court interpret this family dispute, and once the matter is not able to settle in a district court or high court, which land up in Supreme Court. So what does the Supreme Court has to say with regard to the family dispute which happens, and what are the direction given by the Supreme Court in this regard? So which is one of the most celebrated and well-known cases, that is Jagraj Singh versus Bir Pal Kaur. If you guys want, you can write it down. It is 2007 SCC Supreme Court. 2007 Supreme Court. So it is, I'll repeat the name again, Jagraj Singh versus Bir Pal Kaur. In this, the court has stated that the provision which has been given in a Family Court Act and the Hindu Marriage Act which has casted duty upon the court to compulsorily refer the party to mediation is not a mere paperwork, or it should not be just given it. It's a mandatory provisions. Parties has to be referred, and the endeavor of the court is to ask the parties to settle the matter in a peaceful manner as much as possible. See, ultimately the whole idea is so that the party don't spend unnecessarily, their time and money in the lengthy litigation, non-end litigation. Otherwise, it will end up in nothing, and parties would be spending money and time unnecessarily. So to stop that thing, court has given it the direction that it is mandatory for the parties, so that the parties can, settle their matter. Another judgment, which is a good judgment, is that is Baljinder Kaur versus Hardeep Singh, in which the Supreme Court has stated that the stress should always be given on the preservation of the institution of marriage. Just because the matter has been referred to family court doesn't mean that it has to be end up in a divorce. It can be reunited, parties can be reunited, and they should be reunited with the efforts of the court. And for that, the lawyers plays a crucial role. Most of you all are students of law. Eventually you'll be joining the bar and becoming, somebody would be going in corporate, somebody would be going in litigation. So for those who are going to corporate, I don't know to what extent you'll be getting this thing, but those who are coming to litigation, I think you'll be every now and then would be facing some or other such kind of issues where people would be coming up and saying that, look, I have this family problem, and considering the social change with the India is going through, this kind of litigation is in rise. So people would be coming to you asking for direct help. And for that, as a lawyer, it is your duty not to misguide your client and to guide them properly, to help them, to assist them, to find a best possible way out and an equitable solution for that. So for that, here the crucial roles for the lawyer come. So when a party is in a dispute, it's a duty of the lawyer to tell the parties that, look, it's no point lingering on the matter, because it's not a commercial dispute or a property dispute which can goes on for endless. So it's better, it's your life at stake. So try to settle the matter with as much as in a peaceful manner as is possible. In that same Baljinder Singh Kaur versus Hardeep Singh, the Supreme Court has further said the requirement of law and one of the object of the Family Court Act for which it was enacted is to see the family dispute is conciled and achieved social equitable results and eliminate adherence to the rigid rules of procedure and evidence. So generally the courts, you might have seen the statue of the lady, the Statue of Justice, having a blindfolded. So that blindfold indicates that the lady doesn't go, she only weights the evidence. So once she weights the evidence, so that becomes a little technical in nature. So to avoid such kind of technicalities, so parties are free to decide and take any dispute in a peaceful manner, resolve it. So for that purpose, it is important that the family court pushes them, the lawyers representing their party guides them, so that they can, take it in a very positive way, and they both end up in a positive note. And there's no animosity at the end of the day when the litigation comes to an end. So both of them should feel that, look, we have gained something. We have not been at the losing end. You have also gained something. I have also gained something. So to make it a win-win situation for both of them, it should not happen that, look, I have won over you. Because ultimately it's again come the same thing. It's a family. In a family, you can't have a thing that you have won, I have lost. So for that, it is important to maintain peace in this family, that you continue with this, having such kind of things. Then there is another landmark judgment is that, which you guys will see, that is Shiv Kumar Gupta versus Lakshmi Devi Gupta, which is also a landmark judgment in which court has said that the conciliation is the first attempt, and court should always try to conceal the matter, try to reconcile the matters between the parties, so that the family dispute can be resolved in a very practical way and in as much as possible in a practical manner. So this is the few of the judgments which say that, which the recent law says that the endeavor of the court is to see that unnecessarily it is not dragged. Which one is one of the most important aspect in a family matter, which you'll be hearing in news, in social media, is that 498A. Most of the people would see that they say case kar denge tum pe. That's called 498A in the matrimonial matter. So even if it's a 498A matter that is more in a criminal in nature, that can also be resolved. And once it is resolved, everything comes to an end, and that person who is involved in that, that person also get himself free out of it, and he can also go ahead and have a peaceful life. So it's always better to resolve the matter as much as possible with regard to this. So that is the broader aspect, you can say, of this family mediation and dispute resolution, which as a lawyer, we also have a duty towards the society to repay. For the repay, it is very important that, you give something back to the society, so that it is, there's, let's say, peace and harmony prevail in the society for that purpose. Monica, ma'am?
Yes, sir.
I think with this, we have come to the end of it. Can we have some interaction session if students have any query, if they want to ask something?
Students are writing questions in the chat box, but I think they are writing directly to me. So
okay, I have not get it.
Yes, sir. I would repeat the questions.
Hmm.
Why there is a mediation first in family dispute and not in the other dispute?
Okay, that is a very good question. See, previously it was in that sense that family dispute, they compulsorily refer to mediation being a family dispute. But now there's a little bit change in a commercial angle as well. There's a new act which is called Commercial Court Act 2015, in which even the commercial dispute is compulsorily referred to mediation, section 12A. So there's a change being taken place in the other aspect also. So it is not that only in family dispute they're referring to mediation. In commercial matters also they're referring to mediation, which is quite recent, 2015. But in labor laws, there was since 1980, there's a direction from Supreme Court. All the labor matter has to first compulsorily go to a mediation, and then it has to be referred to a labor tribunal or labor court for adjudication. So it's not that, because since family dispute is it becomes prominent, so people think that only in family court they refer it to mediation, but it's not that. Pre-litigation, we use it as pre-litigation mediation. In commercial court, it has started from 2015, whereas in labor matter, it was already in existence. So from there, the analogy is drawn to a family court in 1984.
Thank you, sir. Thank you for answering the question. The next question is domestic violence cases also go for mediation?
Yes, it can be referred to mediation, though it is governed by criminal procedure code, which is quite strictly in criminal in nature, but there is no bar in settling the matter, because that's what I pointed out. Even if a marriage, husband, male and a female living together, that matter would also be referred to a family court. So once that's come there, so every court has a mediation center. So all disputes can be referred to mediation, except heinous crimes. So even if domestic violence is there, so that can also be referred to mediation. There's no harm to it. And it is settled. And it is getting settled.
Thank you, sir. Thank you for answering. The next question is, how many times in a family court a party can file plea for mediation?
There is no specific timeline given to that. Having said that, the first instance, the duty is on the judge to refer the party to mediation. So once the party is referred to mediation, so you can say the ratio is less, but still 50% of cases get settled at the first instance. But once if you miss that bus or that opportunity is gone, then also you can refer it again and again to mediation. There's no specific bar. But generally, practically, it doesn't happen is that once you know that once you have a one round of litigation or mediation, so the other party is not interested. So you unilaterally going will not help. So that's the reason other side doesn't come forward. So that's the reason. But there's no, legally, there's no bar. 1 time, 2 time, 10 times, 100 times, you can go ahead. But legally, there's no bar.
Thank you, sir. So next question is the mediation, the award given in the mediation, is it enforceable? And if the parties deny after some time that now we don't want to follow this award, then what would happen? Earlier, the parties agreed.
There are two aspects to it. Number one, the award given by the family court. It is not an award. Award is the arbitrator which passes. It's an award. The family court, the order passed by the family court is called a decree. That is the same decree which most of the students would have read. It is in a which are read in a CPC. So that decree, using the word decree here means decree is enforceable as per CPC. So once that becomes a consent decree. So once a consent decree is passed, so that becomes legally enforceable as per CPC. So party doesn't have an option to refuse. So once they refuse it, you can apply to the court that, look, before you they agreed and now they're saying no. So either you get that court direct them to follow that direction, whatever they had, or they can also be in some cases be prosecuted for contempt of court. But obviously in family matters, generally court don't exercise that contempt power that easily, unless and until it's a blatant violation of some court order. But generally, court will get it implemented. Court has the system that is called execution. Will get it done.
Sir, there was an interesting question again. A family, they agreed that yes, we will live together after a mediation process. And then after some time, they again have same fight and they came to the court that now we don't want to live together. But the decree was passed to live together. So now what would happen in this case?
Okay. It happens, and it is a very practical question, I would say, and it happens really in real life as well. We have seen that thing happening. So once an order is passed that will live together, so these such kind of orders, you can say it's like once a child is born, somebody get married, you can't assure that person will be alive through, you can't have a legal document saying. So marriage as an institution, you have come to the court, you decided to stay together. So that has happened before a court. So once that settlement has failed, it doesn't mean that you can't separate, you can't part ways. Any order can't be against your life. For example, if tomorrow husband and wife goes to the court, the husband undertook an understanding and mediation or a settlement where they say they both will stay together. Husband came back house and started beating wife, making her black and blue. So it doesn't mean that wife has given a statement in the court, she can't apply for divorce. No, it was done with understanding. In a normal course it would be, but that doesn't mean she has become a slave of somebody that she cannot get away, or vice versa, or husband cannot get away. It happens. That doesn't mean that you're not free to go. Other party doesn't give a right to other party to commit cruelty upon other party. That's all.
Thank you, sir. Thank you for answering. Sir, the next question is how to be a mediator, how to be a mediator, how to be a mediating expert like you are, the ADR expert. So what are the qualifications that a person need? Because you are a lawyer. So is it required that a person should be a lawyer for a mediator?
Okay, see, for a mediator, let us use two terms for that for better understanding: a mediator and a counselor. So that would help you a little better. Me as a mediator, I might not be a counselor, but I'm a mediator. You may say that. So as a mediator, you're not required to have a legal degree, but legal degree is preferred. Reason being that once the previous question was, what happens when both have given an undertaking that they'll stay together and they go home and start having a fight after 6 months, then what do you do? So for that, we say you might have little bit of better to have a little bit of legal knowledge, so that you're not misguided or doesn't take a wrong legal decision, or you take a informed decision. So for that limited aspect you can have. And the other aspect is a counselor. For counselor, you don't need a law degree, because all you need to be a social counselor. You need to understand a counselor party. So that is okay, that you can be. So there's no qualification prescribed as such for both of them, but is that you should be expert. I give you a very good example is that NGOs, women NGOs, every woman NGO have their own counselor and own mediator. So they are not expert, they are not done anything, but is that by virtue of their experience, they know how to solve the disputes. So that's the idea, to give in so that you are able to solve a dispute. But this is important, that if you want to be a court appointed mediator, as I told you already, that there are mediation centers in the courts. To be a court appointed mediator, court makes it mandatory that somebody from law having an LLB degree, or a counselor, psychology subject with a background, should be appointed as a mediator, so that for purposes of court or a government agency, you need to be little qualified as LLB or the prescribed like sociology something. But with regard to like working for an NGO or for other organization, there is no requirement. All is that you need to be a good counselor and mediator.
Thank you, sir. There are a line of questions. Let me read the questions. If you,
No
if
issues,
you,
yeah,
if
sure,
you're
no
allowed
problem.
to.
Yeah, sure.
Yes, sir. So wait, just reading. So the question is, if the party is not satisfied with the mediation, as this was already done. So, sir, the next is, as we know that our law mostly focus on not separating of couples. So do you think that it's one of the reasons of very less percentage of divorce in India?
I think this question is little, I would say, little more not suited to this present situation, because these are law directs the court that you try to push the parties or to make them understand and not to get a divorce. But practically, when you come to the court, when some of them will come and join the litigation bar, they'll understand, they see the most of the litigation ends up in a compromise, and the compromise is to part ways. So it won't be correct to generalize things that there is no divorce, and it won't be correct also to say that okay, the divorces are on rise, and we can't even say that divorces are less. It's upon the parties. But since it's more a social thing, that in India still the divorce is considered as a stigma or something, so people avoid getting into it. If some dispute, they try to solve it and get into it, and most of the time when there's a child, so that further becomes difficult. No one wants in India their child to suffer. So that's the reason you can see. It's one of them.
Thank you, sir. Thank you for answering the question. Next question is, when one person from our brother file a case of property claiming his share and property belongs to great grandfather, and the father of them gave the whole property to only one of them, does the other have a right to file case under family court? This is something out of mediation.
Out of it is out of mediation, but
Yes,
still
sir.
it is better that he filing a case, everybody has a right to file whatever they want anywhere. But ultimately, once if the father is given up the property, then it becomes difficult, for him to succeed in a court of law. So that is something which he'll have to take care of it. But such kind of dispute, it doesn't seems to be the question gives an impression that it is more a property dispute rather than a family dispute. So it is supposed to be going to a property court or a civil court rather than a family court.
Thank you, sir. Sir, there's a question that in a mediation setting.
Ma'am, your voice is not audible. I think it has gone on mute.
Am I audible?
Yeah, you need to repeat your question from the beginning.
Sir, in the mediation center, who is the judge and how one can become that judge?
For mediation center, the judge is the judge who is already a judge appointed by the judicial service. He is given a posting in a mediation center, just a deputation posting. You don't have a separate exams to become a mediation judge. You need to clear your local state judiciary to become a judge there. So once you have cleared a state judiciary, you'll become a judge either in a labor court or a check bounce case or a family court or a family court mediator judge. So these are the, once you are judge, which wherever you sit doesn't make a difference. You are a judge, you are a judge. You are a judge of district, that are state state exams. You have to do it. So doesn't make a posting, doesn't make a difference.
Thank you, sir. Sir, there is again question. Students are continuously texting their questions. So,
Okay,
sir,
no.
I won't be able to take all the questions to this because we have a time limit. The last question, sir, is how do we can make our hold in the arbitration mediation as a beginner in high court or any key feature, sir?
Can you just repeat the question once again, please?
Wait. How we can make our hold in arbitration or mediation as a beginner in high court or any other court?
See, generally, I can tell you about Delhi is for the two aspects is arbitration and a mediation. For an arbitration, you need to join somebody, having a lot of arbitration work so that you can learn arbitration. As simple as that. And for a mediation, either there are various session organization, conducted by high courts, district court, so that you can join them and take this certificate course of 6 months or 14 days or 1 month, 2 months, showing that, okay, you have been trained as a mediator to help the party to arrive at that. So for high court, it is, I think they ask for 10 or 11 years of experience, but for a district court, they don't ask you that experience. So once as a beginner, you can obviously join a district court immediately if you want to be there. But for arbitration, you need to join some office or some chamber who has an arbitration work.
Thank you, sir. And sir, last
Monica,
advice.
you can take a few if you want to if you have 1-2 questions, you can take that. Not an issue.
Okay, sir.
It's not an issue.
So there are questions actually. The students are asking that if there are repeatedly fights between the parties, that is the husband and wife, and once the settlement has been done, so how many times they can come to the court
there is no limit to it. If the fight goes on once and twice, that's what the job of a mediator is. That's what he counsels both the party, that these are the small fights, don't get into it fights. For every fight, you can't come to the court. But if small fight goes on continuously, this shows that something is rotten between between the lines, between the relationships, it's not going to work. Then obviously you have to come only once, and then the dragging starts. You spend your most of the time not in the offices, or you spend most of the time in the court. So again, you have to spend time. So that's the idea, is that once you get into a dispute, try to solve it. So there, see, small fights goes on in everywhere, even between friend, even between mother, father, brothers, you have a small fight. Every small fight don't end up in the court. So once it end up, so that's the idea, is to preserve it.
Thank you, sir. Thank you for patiently answering all the questions. And sir, this is last question from my end. Sir, can you give advice to our students that how they can proceed with this career in family dispute resolution? As you are an expert, how can they be an expert in this field?
My advice to student would be that whenever you just complete your graduation and get into practice of law, try to join some office or some court where they have such kind of mediation options. Like whichever place you start with the district courts. District courts gives you the first-hand information and first-hand exposure to meet the parties directly. Because in a high court and a supreme court, what you would be getting is only an appeal, a complete file would come to you. No one is going to come to you to meet personally. There would be, but number of people would be less. Whereas in a district court, you get a completely raw exposure. People are going to come not with the file, but only with their problems. So they're going to spell out their problem to you. The more and more problems you try to listen, and the more and more study you do and take guidance from the person under whom you're working. So that taking the facts from there and guidance from the person under you're working will help you yourself find a way out. So it is important to join a good office and to start from a district court. If you really want to, understand the basics, that is the most important, according to me, it would be.
Thank you so much, sir. Sir, students wants to join you in the social media if you allow, because they are asking that how we can connect you in future.
You can connect me through Monica ma'am. I'll always be available. Monica ma'am can share my number if required. You can join email ID. I'm not much active on social media. I feel it will consume most of my time. So better we spend some time in the court. So I'm a little less active on social media. You might not find me there.
So they can mail you their doubts.
If the kids can help me and create something on social media, that's a different aspect.
Yes, sir. Thank you so much, sir. Thank you for being here. Now, I would like to request our Assistant Dean, Mrs. Monica Kurola, ma'am, to give a vote of thanks to you, sir.
Thank you, Monica. And it's been a wonderful session where Advocate Deepak Agarwal has very clearly demarcated how these family cases and how the family court deals with the cases when it is put. And it's true that the courts are one-way alley. So whenever parties come to the court with their problems, then sometimes it becomes difficult for them to retract their allegations against each other. So this mediation helps to reduce the differences between the parties, and they can compromise, and they can try and live together. And of course, we've truly seen, and Deepak has said, that in Indian society, the stigma of divorce is still there. So even for the families, for the health of the families, in which not only the spouses and the children are there, but also it is for the community's welfare that we have healthy family units which can contribute towards the well-being of the community. And lawyers are playing a very important role in ensuring that the disputes between these people do not escalate, and how they can reduce it. And I'm sure that our students also will think about it and understand the values of the system.
Ma'am, you're not audible. Hello.
I think some technical issues. Yeah.
Yes, sir.
Hello. Sorry.
Ma'am, now
Hello.
you're audible. Yes, ma'am, you're audible now.
Oh, I'm very sorry.
No issues, ma'am.
Okay, so it's been a wonderful session, and Deepak, Advocate Deepak Agarwal, I'm sure that his interest and his enthusiasm has got the better of our students who are ready to join him and contact him on social media. I'm sure that he'll be a part of our ICFI family in the coming days, and we'll keep getting back to him. And will take his help to disseminate information, to encourage students to take up this ADR in their practice, and to be able to become good mediators. So I thank Advocate Deepak for kindly consenting to give this, and it's been a wonderful learning lesson for our students. So thank you. On behalf of ICFI University, please do visit our campus whenever you are here.
Sure, ma'am. Sure. Thank you so much, ma'am. Thank you. Thank you all the students for patiently listening to me. Thank you so much. Thank you for the question. Thank you.
Wonderful hearing you.
Thank you.
Over to you, Monica.
Thank you, sir. Thank you, ma'am. Ma'am, after your permission, and sir, after your permission, shall we end the meeting now?
Yeah, sure. Yeah. Subject to ma'am's approval, we can. Sure.
Please.
Yes, ma'am. Thank you, everyone. Thank you, sir.
Thank you.
Students, kindly fill the feedback form, which is in the chat box. We'll wait for 2 minutes for you to submit the feedback form. And we'll end the meeting in 4 o'clock, 5 minutes, 4:05. Okay, thank you, students. We are ending the meeting now. Praveen, sir, am I audible? Praveen, sir.